Ladies and gentlemen, today I have the pleasure to welcome Professor James Grogan. Professor James Grogan is a professor of law at the University of Loyola School of Law in Chicago. And today we're going to discuss the history of the legal profession, ethic, and codes of conduct for lawyers in the United States of America. Professor Grogan, again, thank you very much for joining me under the human rights tree.
Thank you. It's an honor to be with you today.
So, as I indicated the topic of this conversation, my first question will be, can you tell us a little bit how the legal profession evolved from the period of the colonies until today?
Well, it has been a development, and it has been a slow development. But although many of our colonies developed out of the English system of barristers and solicitors and inns of court didn't really translate well to the rough and wild environment that people found themselves in. And especially as people started moving away from the colonies and going further west, the legal profession was pretty much almost primitive, I think you could describe in this country. That the legal profession were basically uh, itinerant attorneys. They would sometimes settle in communities and help people with legal needs, but it was nowhere near as developed. We start seeing development of the legal profession in this country in the 19th century. You know, what's really interesting, Alpha, is that at some point in time, at least one of the initial American colonies did not want lawyers at all because they wanted the place to be flourishing and happy. So they didn't
Okay.
even want any part of lawyers. So, but people need lawyers
Yeah.
for a host of reasons. And the rise in the profession, again, was very slow. The development was very, very prolonged. But as people's needs increased and as society became more complicated, the thought was we need to do something. So we see with the growth of populations, we see the growth of legal professions, usually in urban areas.
Mm.
And with this development of the profession, came a sense of identity that if we're a lawyer, what do we stand for? You know, who
Good,
are we as a profession?
good
So,
questions.
yeah, the first thing that this growing profession, they started looking inward and saying, how can we define ourselves? Now, when you think about it, it's quite amusing because the only people that were practicing as lawyers for all intent and purposes were white Protestant males.
Oh,
But
okay.
but nonetheless,
Mm.
there was this thought that we need to look and define who we are. So we see in the 1830s a professor in Maryland named Hoffman wrote the first text on legal ethics. And this legal ethics text was sometimes used in some of the law schools, but as you know, with the legal profession, not everyone attended law school. Many
Mm.
people just read for the bar, like Abraham Lincoln. You know, you work for a lawyer, you study, and then you take a bar exam and you pass a character and fitness review. So
Mm.
the protocols necessary to become a lawyer were they varied from state to state, and when the country was developing, there was one commonality, however, that we see developing in the 19th century, and that was that the courts, the highest state court in these states that were coming into creation, were
Mm.
setting the standards for the legal profession. It was the courts, usually the state Supreme Court, that was starting to license lawyers. This happened, for example, in Illinois,
Mm.
beginning in 1818 when Illinois achieved statehood. We see right after that the courts starting to, if you will, take possession of the legal profession. And that's why, even to this day, in almost every state, lawyers are regulated by their state high court. It isn't the legislatures as a general rule that governs the legal profession. It's the state high court.
I see.
So we see with these state courts starting licensing proceedings and the beginning of this identity process that a profession has to have standards. By the late 19th century, we see one state, Alabama, as adopting a code of ethics
Hmm.
in 1887. And when we look back at these ethics codes, they're one gentleman to another. You know, they're very measured
Mm.
but the one thing in all these early ethics codes is please don't solicit business. You
I
know,
see.
but other than that, it was
Mm.
pretty well, oh, lawyers, you should do this. You should hold the profession in the highest regard. You should operate with clients with integrity. Again, but that's what lawyers typically do. You treat your clients with integrity and respect. And we see these early ethics codes, a high emphasis on respect and relationships and managing, if you will, our matters before courts. Now,
I
this
see.
started snowballing after Alabama developed this, and because with the gains in our country, Chicago, for example, starting in the 1830s is a teeny little village, and millions of people living in Chicago at the end of the 19th century. The thought was, you know, these old ethics codes that are developing higgledy-piggledy, we have to have some, if you will, unifying factor. And that's where the ABA stepped in. The American Bar Association basically started as a little bar organization in upstate New York, and it developed rapidly and then had a national presence. Now, the American Bar Association is just a trade association. It
I see.
has no, if you will, a power in the individual states or territories at the time. But they had a bully pulpit. They had a presence around the country. And in 1908, they developed what was the first considered national ethics code, the ABA Canons of Professional Responsibility.
Mm.
So that was 1908. And then the ABA said to the states, take a look at these codes. And it's kind of unique because the ABA looked to a lot of what Alabama did years before. And they promulgated this ethics code and they said to the states, adopt this. And states were like, no, maybe we should, maybe we shouldn't. Not every state did. Because when we look at the legal profession in the country, I've also always described it as being very tribal.
Okay.
The state that licenses you takes incredible steps to preserve the power over their lawyers in terms of jurisdiction, saying that no lawyer from out of our particular tribal area can come
Yeah.
here. You know,
I see.
so each state was an independent fiefdom, if you will, setting the standards. And some states adopted these ABA canons, which were largely aspirational. Um, and after a period of years, people started realizing, wow, the legal profession is changing very rapidly, especially with two world wars, you know,
I
and
see.
the Great Depression and the movement to people to cities. You know, America was largely an agrarian economy and an agrarian culture until the end of the 19th century. You see these big cities developing and pockets of population throughout the various states. So in the 1960s, the leaders of the ABA looked around and said, you know, we've got this old ethics code from 1908. It's very lacy and quaint, but it doesn't meet the
Mhm.
needs of professionals in the 1960s because a big firm in 1908 was 5 or 6 lawyers.
I see.
And now we have firms with dozens and dozens of lawyers.
Mm.
And there's also the recognition that not every lawyer is a trial lawyer, that we, as a profession, are very diverse in what we do.
Mm.
You know, you might be very good at counseling a client as to drafting of wills and trusts, but you want nothing to do with trial work.
It's
Or you
true.
may be very adept at criminal defense work, but you want nothing to do with antitrust law. It's
Mm.
just, lawyers are there to meet the needs of clients. And because we have a huge population with these incredibly diverse needs, you need to have legal representation in each of those niche areas. So that's why the profession started developing. Plus, I'll be honest, Alpha, in popular culture, we
Mm.
see a profusion of movies about lawyers, and a lot of
Yeah,
people thought this is really neat. You know,
I
um,
should be a lawyer.
yeah, to be a lawyer. So we see this development in the 1960s said these old codes aren't good because they don't really serve in the capacity as a commandment that if I do something bad, there can be repercussions. In other words, what I'm trying to say is you can adopt an ethics code, but what good is an ethics code unless there's enforcement? A mechanism to say, you did wrong,
Yeah,
don't do it again. Or you did wrong, you should never be exposed to human beings again.
yeah.
You know, so we see this movement in the 1960s. A brand new ethics code is adopted by the ABA, and that brand new ethics code basically had a lot of commandments. Don't commingle your money with your clients, and don't advertise your practice in this way. So there were a
Mm.
lot of these commandments. Well, by the 1980s it was learned that those old codes, they just don't cut muster anymore.
Okay.
And in 1983 the ABA promulgated what's known as the Model Rules of Professional Conduct. And unlike the prior two versions of ethics codes, this one had a lot of merit because it not only had rules that could be prosecuted if there was a violation, but there were a lot of comments contained with these rules that give lawyers practical guidance. And that's critical because not, and this is important in my opinion, about ethics codes. Um, they're not going to guide you in each situation where a problem develops.
Mm.
The rules are intended to cover, very repeating instances and common areas, but it's not like a cookbook. You know what I mean?
Yeah.
That if a lawyer does something that's not completely discussed in the rules, well, you got to be able to deal with that. And the ABA model rules in 1983 sought to accommodate that. And then the ABA went around to the states and said, we think we finally have it. The third time is the charm. The profession now is more diverse, and we are a whole lot bigger. And
Mm.
we've got it doesn't look like it did 80 years before or 100 years before. So with the 1983 rules, the ABA went and said to the states, we've got to do something to be consistent. And they were very successful in this regard because the ABA has put together this blueprint. They went to the various states, and almost all the states and the territories have adopted a version of the ABA model rules. And that's important because, we talked about the fact that the practice of law was very tribal. It was, delegated to a certain area of practice. Well, now we have telephones. Now we have Zoom. Now we have all these technologies that
Yeah.
allow us not to stay within a community. But
Mm.
you still have some reluctance of these jurisdictions to say, how dare you open our borders to people that might come in here and practice? So, what we have beginning in the 80s is a real emphasis on uniformity. So that if I
Okay.
have, for example, I have a license in Colorado and Illinois. If I do something in Illinois as a lawyer, and it's prohibited by the Illinois code, I would hope that in Colorado the same conduct would be prohibited,
I
that there
see.
wouldn't be these disparities of rules and guidelines. And pretty much that's what's happened. And it's really been a positive thing. We are now really, although there are variances in states, Illinois, for example, let me give you the difference. The ABA says if I have a client and that client tells me that he's going to take an act in which he's going to kill somebody or hurt somebody.
Mm.
The ABA model rules makes it optional whether that lawyer has to do anything. In Illinois, it's mandatory. I have to take some reasonable efforts to
Mm.
stop my client from committing this act that could cause death or serious bodily harm, even to the client. What if a client threatens suicide?
I
What is the
see.
lawyer to do in that context? So,
Mm.
except for those little variants, the nice thing about the ABA model rules now is they really do serve as a national format. And that most of the states, like Illinois, it's like 98% of our rules are identical to the ABA model rules. So that's been very helpful.
I see. I would like to understand what trigger, if you can give us case precedents that open the eyes to the Supreme Court and the state level saying we need a regulation here.
Uh,
Do you
uh,
have any cases that
you know what?
put
I'll
us
tell
in that
you,
situation?
believe it or not, nationwide,
Mm.
the era of the Watergate problems
Oh,
in Richard
okay.
Nixon's administration. It
Yeah.
was really fascinating. A significant percentage of our presidents and
Mm.
vice presidents in the United States have been lawyers.
Mm.
And with the Nixon presidency, it was fascinating because his first vice president, a man named Spiro Agnew, was a
Mm.
Maryland lawyer who was sent to federal prison and disbarred. Richard Nixon himself was, of course, left office,
Okay.
but he was disbarred in the two states he was licensed,
Hmm.
in New York and in California. And there was
Mm.
a groundswell of support at this time to say, this is terrible. And we look at the Watergate era, we see a lot of the people engaged in bad acts were licensed lawyers. What are you going to do about it? So we see a response by the law schools to
Okay.
make students study ethics. Now, is
Mm.
this helpful? Bad people are going to do bad things. You want to minimize that risk, right? But sensitizing people to these concepts is important. Plus,
Mm.
I'll be honest with you too. Give you an example. In Illinois, there was already a movement at the time of the Watergate era to
Mm.
do something because the profession was growing in such great numbers. And the bar associations in Illinois used to take care of these ethics cases on a voluntary basis. They were getting swamped. They couldn't do the work. So the Supreme Court in our state and a number of other states said, we've got to professionalize this. We've
Mm.
got to, a lot of people say the word bureaucracy is bad, but it's not always bad.
Mm.
It was the consensus of a lot of the states that we've got to create a mechanism, a bureaucracy to effectively deal with these issues. Because if a consumer has a problem with a lawyer, should that consumer wait 5 years for a bar association on a volunteer basis to consider the matter? It was just not workable. So
I
we
see.
see with the Watergate era, with
Mm.
a public consensus that things are not doing well, and just the overall growth of the profession. And the press is saying, what are you people doing? That we see this response. So we see the growth of agencies and professionalism,
Mm.
and to the point where it's gotten today. And, we're dealing with huge attorney populations. How many lawyers are in this country? We're really not sure. The
Yeah.
ABA posts numbers, but those numbers can be deceptive because I'm counted as two lawyers,
I
in
see.
their count because I have two licenses.
Mm.
So the bottom line here is it's critical for states to adopt a common sense,
Mm.
reasonable code of ethics for their professionals, and not just legal ethics, medical ethics too.
I see.
But to have an appropriate standard of conduct and to have a mechanism that fairly but quickly addresses the issues raised by any perceived violations of those codes.
I see. Often we see rules dictated by the ABA, but who are those members? What give them a certain legitimacy to come up with rules that are adopted around the country?
I like that question. Because as I tell my students,
Mm.
these ethics codes are the result of a political process.
Oh,
And by a
okay.
political process, this is what I mean. The
Okay.
ABA is comprised of members,
Mm.
and the ABA has a board of governors, which are people elected by the membership. And those boards basically are in charge of either accepting or rejecting proposals to adopt new ethics rules, amend old ethics rules, anything dealing with the ethics code. The
Mm.
ABA has a study process. They get input from various people, professionals, professors, the public. They go to committees, and eventually someone comes up with a suggestion that let's look at a proposal. And they sit around and circulate it to all the ABA committees, and it's a big organization.
Mm.
And then eventually there is somebody that promulgates changes before the Board of Governors. So
Mm.
you'll have a room full of hundreds of people twice a year at the ABA meetings, and they are going to almost like a Congress or a parliament reviewing rules. And, um, it's an inartful term, but it's meaningful. It's making sausage.
I see.
It's a political process. Sometimes the political process works very well. Sometimes it doesn't. Sometimes because of a perception that we need to protect lawyers too, that proposals are sometimes watered down. Let me give you an example where you see that this political process at play. If I'm a lawyer and I receive a letter from my opponent, and I realize that my opponent has sent me something that he didn't intend to send me. He intended to send it to the client, but someone put it in the wrong envelope.
Mm.
Well, under proposals, a long-standing obligation, if I know something is misdirected to me, most people would say we got to return it. But
Yeah,
the ABA couldn't find a consensus there. So the ABA left it at if I get something misdirected, I must call to the attention of the person that sent it to me.
I see.
There's no provision that I have to return it. The
Mm.
thought being, well, I put them on notice, let them take whatever legal actions necessary. That showed you that they couldn't get a consensus that in most places people would say, oh, just return it if it's misdirected. They would say,
Mm.
so it's a political process, and the thing is these rules are very organic. They
Okay.
change based on the needs of people. Lawyers now are wrestling, Alpha, with the issues surrounding artificial intelligence. I mean, this is the hottest topic in professional responsibility. Is it a tool or is it something more? And being lawyers, it's like, okay, if we use it as a tool, how do we charge for it? You know, and the ABA sometimes cleverly drafts ethics rules and
Okay.
provisions
Mm.
to be kind of broadly written. So
Mm.
the current rules basically don't talk in terms of artificial intelligence.
Mm.
But they talk in terms of technology and that it is incumbent on the lawyer to be competent. And in furtherance of that necessity to be competent, the lawyer must understand the benefits and the drawbacks of technology. That's
Mm.
basically all it says.
I
So
see.
it's in the lawyer's lap to deal with these huge issues.
Yeah.
And eventually there will be
Rules. Mm.
rules and modifications.
Yeah.
Again, it's organic. It moves with the times. When I was a young lawyer, the ethics code provided that lawyers could communicate via telegraph. I mean, that's how bad it was.
I see.
And our modes of communication have improved a little bit since the era of the telegraph and the
It's
quill pen.
it's true.
So these rules always have to change to
Mm.
meet the abilities of lawyers to competently represent clients.
I see. I know for sure when you come to the legal profession, state have the, like you say, is a clean. They have little autonomy on deciding who is lawyer. But in general, what are the requirements to call we need to have to be a lawyer in United States?
Um, you- Most jurisdictions provide that you have to have a high school education or the equivalent of, because if
Mm,
I come from a country outside the United States, there may
mm,
be a completely different system of education,
it's
but I
true.
would otherwise meet all the qualifications.
Yeah.
And some states like Illinois
Mm,
require some degree of college work. You don't need a college degree in many states to become a lawyer. But
really?
as a, yeah, but as a practice, you just think, I think in Illinois it's 90 hours of acceptable college work. At,
Oh,
at,
okay.
at a university comparable to where graduates would be admitted to the University of Illinois, so some
Mm,
graduate level studies,
okay.
and then law school,
Mm,
which in most cases is going to be a 3-year program. There's deviations from that, of course. So
mm,
you have to have a good educational background.
mm,
In some jurisdictions, like Wisconsin, for example, if you go to law school in Wisconsin at Marquette or the University of Wisconsin, and you want to practice in Milwaukee, you don't want to leave Wisconsin, you don't need to take a bar exam. They figure you've gone to a Wisconsin area law school, it's good enough. You'll get licensed.
I see.
Now, when we say that, the requirements are educational background. You have to be of good fit moral character. So if you have 40 felony convictions, it's going to be a little difficult to be a lawyer because there's a background search.
I see.
There is a bar exam in most jurisdictions. And right
Mm,
now we're dealing with a whole lot of interesting development with bar exams around the country because a lot of people are saying the existing bar exams that have lasted for decades and decades aren't really adept at
mm,
determining people's qualifications to practice law.
mm.
So there's a movement for the next gen bar, a different rollout of what should be required in looking at people. So we have educational,
Okay.
academic, character, and fitness, and those elements combined are what make a lawyer. And you know the thing was, it used to be there were a host of states that didn't want you in their jurisdiction. You
Mm,
know, it was really hard to get admitted in what used to be called the Sun Belt states, where people wanted to go where it was warm in March, you
I
know.
see.
And so they had a little more restrictive entry provisions, but that's all been dissipated over the years.
Mm,
And another good thing is a lot of states now are opening up their doors to saying, why do you have to sit for a separate bar exam? You sat for a bar exam 6 months ago and passed in that state.
yeah.
Come out of board in this state. So there's where we see movement that they're getting away from this limited tribal sort of mindset and
Okay.
trying to open it up. Now we're a long way, and I never see the day in my lifetime that there will be
Mm,
a national license. I just don't see that as happening.
I see.
Um, the states are just too invested with keeping the status quo in that regard. And the states would say we do it better than would be found at a national level anyway.
I see.
Um, what does it take to be a lawyer? Hard work, discipline.
Mm,
You're trying to see if someone has good judgment, good logic, and thinking abilities, and understand that your job is to provide the best you can for your clients.
I see.
That's the critical factor. You know,
I
can
see.
can you pursue your client? Because I spend a lot of time in my classes talking
Mm,
about agency because it's not the lawyer's cause of action. It's
mm,
always the client's. The client is always the principal, and the lawyer is the agent.
I
So as
see.
an agent for a principal, I have a lot of power, to decide how we're going to do things. But ultimately, it's my client that makes the big picture decisions.
The decision.
Yeah,
I
plead
see.
me guilty. Exclude my brother from my will. You
I
know?
see.
Um, it's really up to the client in
Yeah.
creating this agency, which can be difficult because what happens if I'm assigned to represent a 6-month-old child
Hmm. Yeah.
or a 95-year-old person in a nursing home
Hmm.
that's pretty well without capacity to even know who I am?
Yeah.
You have to be able, as a lawyer, to accommodate the differing needs of your clients,
Okay.
adapt to them, and
Hmm.
yet still fulfill what the ethics codes provide in terms of competent representation.
Yeah. Um, as we know, when you lay out the requirement to become a lawyer, as we became a lawyer, we are a lawyer now. We know lawyers have duties and responsibilities, and I see duties and responsibilities towards society,
Mhm.
toward their client, toward the profession. Would you mind just allow us to go through those three aspects of the issue? Lawyers' duties and responsibility towards society.
That's a great question because
Mm,
we may be in a situation as a lawyer representing people that may espouse views that are
mm,
not consistent with the overall good of society.
oh,
Uh, you know, and here's the thing. I may have a client that
mm,
is so offensive and repellent. This person is an avowed racist who believes in racial war,
mm,
and yet that person has been charged with crimes. If I'm a criminal defense lawyer, I'm probably to be successful in that area of practice, have to say, I don't care who the client is. It's the
mm,
process, it's the system that all clients have the right to a fair and impartial trier of fact.
I see.
And if this person is so repellent and awful that I just can't represent them, well, I may have a conflict. I can't represent them. But there will be lawyers out there that say the system as a whole needs to be protected. Now, having said all that, I think as a group of professionals, most lawyers are very good at trying to give back
Mm,
to helping society in that way, to doing what they do in terms of charity or pro bono work, meaning free legal work for people.
mm,
Um, you hope that people give back. At what point in their lives they decide to give back, that's another question.
yeah.
And they can do it in a number of different ways. I was amazed a number of years ago to see lawyers and a number of my students that were at the airports telling people what their rights were for the
Okay.
fear that they were going to be turned away at the
Mm,
borders.
mm,
And you know, that's really important. Lawyers have a role and a responsibility. If they choose not to do things of an extracurricular nature to help society in general, oh well, that's people. But I really think most lawyers want to do the right thing in their
mm,
own personal lives and try to do the right thing and try to help clients in the best way possible. And there are many, many lawyers who do things similar to doctors,
I
Doctors
see.
Without Borders, who go to different places to try to
Mm,
help. A lot of our changes in American society are attributable to lawyers who made a lot of brave decisions to travel around the country. I think I had a professor at Loyola,
mm,
Professor Norman Amaker, who was in the forefront of the NAACP's efforts at civil rights in the 1960s. And as a lawyer, he would go all around the country and into places that were not receptive to either him or what he
mm,
was saying. And he viewed that his contribution to society was to make sure everyone was protected pursuant to the Constitution. And I had the opportunity to learn from him, but I also had the opportunity to observe his life and saw what good came about by virtue of his efforts.
I see. When you come to the relation between lawyers and their client, What are the duties and responsibilities of a lawyer on handling a client?
Well, essentially there's four core duties. I mean, there's a lot of, but I look at
Mm,
four core duties, and the one most principal duty is competence.
mm,
I don't have to be perfect. I just have to really know what I'm doing.
yeah,
So communication. I
mm,
have to let my principal know what I'm doing on their behalf.
I see.
Um, in addition, I have to competence and communication. I have to speak to the client with candor. I have to
Mm,
be honest to the client. I can't sugarcoat. If you're my lawyer and I'm going through criminal trouble, I could say to him, look, yeah, I know you'd like me to go to trial, but we've got like videotape showing you committing the horrible act. We've got this, we've got that. You know what?
yeah,
I really think our best job here is not a jury saying no. I think it's a matter of let's try to get the best plea for you.
I see.
It's candor. And I think with those three elements and conflict free too,
Mm,
conflict free. Conflicts cause big problems, either because of a lawyer's financial stake in something, or they're blinded by relationships and can't see the best way to address a problem.
mm,
Uh, it's really interesting that with that question, because the way the rules are structured, one of the first rules you'll read with the ABA model rules, and I call it the foundation stone,
mm,
is rule 1.1. It's competence. It's
okay,
right at the bottom, and all the other rules are built upon this concept of competence.
I see. What about the lawyer relation with the justice system and the legal profession? How a lawyer should conduct toward another lawyer?
Well, I always, I was very fortunate
Mm,
in my career. And
yeah.
why is that? Because almost all of it was spent in an environment investigating, prosecuting attorneys for professional misconduct. And there were a number of lawyers who
Mm,
regularly represented attorneys in trouble.
okay.
And it was a great experience because some of the best lawyers in the state represented some of the worst. So I got to learn from some of the best lawyers. And
Mm,
some of those, I mean, almost all of those lawyers uniformly realized I've got to go from A to Z.
I see.
And I want to do it as quickly, as painlessly as possible because in the long run, that
Mm,
helps my client. If I can let the world and the justice system see what has happened here,
mm,
they will probably do the right thing, but it's my job to bring all that out. And I'm not going to waste time and I'm going to be totally professional. You know, the ethics code isn't like Emily Post, that when you
mm.
take a cup of tea, you have to have your finger raised in a certain way. Let's face it, it's tough. Um,
Yeah,
if I go to a criminal courthouse, there can be a lot of, you know,
yeah.
emotion between lawyers. And the job is to remember your goal, not to get personally involved. You're
Mm,
the agent. Because if once you're personally involved with something, that
mm,
limits your ability to be objective, to be able to advocate for your client's case as best as possible. There was a judge who told me that when he had teenage children, he said having children of that age is like putting them in a boat in a stormy sea. You can throw them a rope, you can throw food toward them, but
mm.
whatever happens, never ever get in the boat with them.
I see. Don't get involved.
Don't get in the boat. Help them, support them,
Mm,
because you lose that objectivity. You lose
mm,
that ability to stand back and say, oh no, this is what we're going to do. We're going to basically get another boat, put it here, protect you from the waves. It's just, and it's been a good rule of thumb, even in the legal profession, that you have to take a step back.
mm.
Wherever possible, try to understand that this is your client's matter. It's not your matter. And that's difficult. That's difficult,
mm,
especially if you've got that beautiful board behind you with causes that mean something. And
mm,
it's hard when people are trying to attack a client who understands those principles, wants to adopt those principles as a rule of life, and someone's trying to defeat your client from expressing those views. So it can be very difficult.
yeah. As we know, the legal profession can be very challenging,
Mhm,
and often lawyers deal with a lot of stress
mhm.
that can result to mental issues or using drug. And what are the instruments we have in our hand to help those lawyers?
You raised one of the most vital questions.
Mm,
It not only deals with the legal profession, but all professions.
mm,
Um, if I have an airline pilot, I want to make sure that pilot is healthy.
yeah.
If I have a surgeon, I want to make sure that doctor is healthy. And if I have a lawyer, I want to make sure that lawyer is healthy. But we're people. We suffer from the same frailties as everybody in every other profession. And the legal profession is incredibly stressful. We don't deal with landing and taking planes off, but we're dealing with people's sorrows and bad times and
Mm,
critical factors, and we don't want to make a mistake. And a lot of times we're representing people who, as persons, we really don't like or respect, but we have a job to do. But this
yeah.
can cause all sorts of stresses, especially with economic issues and
Mm,
managing a business. And you are correct to raise this because where we see lawyers run afoul with the ethics code, many times it's not because they're bad people, certainly.
mm,
It's because they suffer from a lot of frailties and they're not healthy.
okay.
And if someone has gone through a period of deaths of close family members, of a death of a child or a significant other, the impact can't help but deal with how you're going to practice going forward. So uh, the nice thing we see a development over the years. This is in the wake of the ethics code. We saw so many lawyers being removed from practice because they were having human problems.
Mm,
And courts consistently around the country said, if we can save these lawyer lives, chances are they're not, there's a certain percentage of lawyers that do wrong. And I like to say they tie maidens to railroad tracks, with the big
mm,
mustache and, they're intending to do harm to people. And you,
yeah.
you try to keep those people out of the profession, but they sometimes get in. But for most situations, the lawyer has violated an ethics principle because they're not healthy. They're
Mm,
not returning phone calls. They're not going to court. Why? Because they're suffering from a major depressive disorder. They can't get out of bed to go into court that day.
mm,
So you've got this problem with you're supposed to help clients. You can't help the clients. Well, someone's going to get hurt. What do
mm,
you do? Fortunately, in almost every jurisdiction, there is an emphasis on lawyer health. And for example, in Illinois, we have something known as LAP, the Lawyer's Assistance Program.
I
And
see.
that's a program that can help lawyers go through the process of dealing with mental health issues, of alcoholism or addiction to control substance issues. And the nice thing, they're available not only to deal with lawyers, but also judges who, because judges are just super lawyers, they're
Mm,
one step beyond, or law students. The one thing that is clear from statistics is that young people get into law schools being incredibly optimistic and idealistic.
mm,
And within those couple of years in law school, the rates of depression just mount profoundly.
mm,
Suicidal ideation,
mm,
harmful habits, so that the lawyers' assistance programs are available to also help students. And luckily, I've been involved at Loyola for many
mm,
years now, and Loyola's law school believes in those mandates that if someone is not doing well, can we get someone some help?
okay.
Because you probably have a good lawyer here. It's
Mm,
just they're not going to be a good lawyer unless they can deal with some real personal issues.
I see. You mentioned it during our conversation, the emergence of new technology in the profession, how the ABA or legal institution are dealing with those new emerging technologies, and
Um,
how are they able to adapt to the new situations?
Yeah,
Well,
it's what typically happens is there's a response from the profession with growing technology.
mm,
And when I think of growing technology, I'm going from an era where the telephone was the only mode of communication.
mm,
And then we
yeah,
struggled with emails, and then we struggled with texts, and then we're struggling with social media. How do we deal with these changes? Um, a couple of things. The bars do say, look, we perceive there to be a problem here. Lawyers say, I perceive there to be a problem here. And there's a discussion. How do we address this issue? How do we change the ethics code to deal with these real life situations? So there's a response. But there's one other thing that when we talk about regulation that we really haven't discussed, and it's this. The lawyer who represents a client also has an affirmative obligation to be competent in a civil context. And by that, I mean, if the lawyer doesn't follow appropriate standards, that lawyer is amenable to being sued in malpractice by a client.
mm,
If there's a misuse of client information, for example, if I'm as a lawyer selling my secrets on the dark web about my
mm,
clients, not only can there be a discipline response where my license is at stake, but the clients can bring an action. So malpractice insurance companies are, if you will, sometimes the canary in the coal mine, seeing these technological problems, being
mm,
able to, how do we advise our insureds, the lawyers who buy a policy from us, how do we advise them to best protect themselves from scammers, from people intending harm?
I see.
Little things like, for example, if I'm a lawyer at a coffee shop, am I using the free Wi-Fi to deal with legal business? I hope not. I hope not. Someone is reading that in some corner of the universe.
Okay.
Don't want to do that. I mean,
Yeah,
here
it's
the ethics code says nothing about VPNs,
yeah,
but
it's true.
it's the malpractice carriers that advise their clients, look, you can't communicate this way. It's
Yeah,
dangerous. You can get hurt, the clients can get hurt.
I see. Often when we go to school as a student, we learn on how to deal with laws. This is our main goal. But when you become a lawyer, you have your own private practice. You deal with client money. So how can what precautions a lawyer should do to kind of act professionally toward somebody else's money?
Great question because so many lawyers run afoul of that. I like to teach in my classes that a significant number of students were art history majors, and they
Mm,
can really talk about the difference between Baroque and Rococo Western
okay.
art. But the bottom line here is they never took an accounting course, they never took a business course, they were afraid of numbers, and now
Okay.
they're in practice and have to deal with client funds.
Mm,
There's a suggestion that says whenever possible, don't touch client money ever,
okay.
never.
I
But
see.
having said that, the bigger the firm, the more protections. If you're a young lawyer in a firm, you're not going to worry about that. Someone in the firm will. But if
Mm,
you're a sole proprietor, as you've mentioned, that's more difficult.
mm,
So I advise sole proprietors a couple of things. First, deal with your malpractice carrier to see, what's the best way to structure things. Talk to an accountant, preferably an accountant with a law degree that can help counsel you to set up the appropriate books and records.
mm,
Take a couple refresher classes on how to best manage client monies and property so that you don't have a mistake. You don't accidentally deposit client settlement proceeds in a joint bank account that you hold with your brother. You know, it has to be a separate identifiable trust bank account.
Mm,
And the bottom line here, there are, if you're a lawyer, there's a very, very, very critical and helpful organization, the Lawyers Trust Fund of Illinois. It's called LTF, and
mm,
they are more than happy to give lawyers help with how to fashion their books and records. And there's resources out there to help lawyers, but it's so critical that if you do touch client funds or property, that you safeguard them. And the reason for that is because we're fiduciaries. We
I see.
can't benefit from that
Mm,
agency relationship by disadvantaging a client.
I see. As you indicated, we live in the era of social media, TikTok, Facebook, and things. How can you deal when it comes to advertising your work? What precaution a lawyer should take to avoid to getting himself in trouble?
Well, great questions
Mm,
because our ability to communicate, our availability for services
mm,
exists in a way that it didn't 50, 60 years ago, where advertising was essentially prohibited.
mm,
The thing to think about is when we're dealing with marketing concepts or trying to sell my services, I'm protected by the commercial speech doctrine. The First Amendment gives my ability to advertise a degree of First Amendment protection. In furtherance of that, there should be great liberality in allowing me to market my way myself in any different forum. So if I want to do TikTok, if I want to do other social media,
mm.
fine. Here's the critical bottom line is whatever information I impart, it's got to be honest.
I see.
That's the critical factor. If I say to somebody, I've successfully handled 500 million dollar plus verdict cases, and you never have even handled one, that's a
Mm,
problem. That's a problem.
I see.
That I want to basically go on TikTok and I have a raven on my shoulder and I want to say that, the bird and me are together. Who cares? Who
I
cares?
see.
If I'm going
Yeah.
to market myself in such a way to attract business, go for it. Go for it. But make sure it's honest and you don't deceive consumers about what you can do for them and how you're going to do it.
Um, when it comes to pro bono, why you think pro bono is so um, important in the American legal system?
Too many people don't have the opportunities to have their issues addressed in an appropriate way.
Mm,
And much of what we do in the legal process is revenue driven. Yes, I can help you, but to help you,
you
I,
have to
I would
pay.
have to not work and earn an income in this regard. If I am taking a really high visibility case, that may be my whole practice for 2 years.
Mm,
The nice thing about it with pro bono, for most lawyers that I know, the most rewarding part of their practice is the pro bono because they feel like they're doing someone some good that
yeah,
otherwise couldn't seek redress in any forum.
that's it.
That's the nice thing about some big firms that they offer some pro bono opportunities.
Mm,
Uh, I can't tell you how many of my students say, I got into practice, it's hard. I never see my family. I used to have a
mm,
dog. I don't have time to walk the dog anymore, so I don't have a dog.
I
But
see.
they will say, I'm assigned to this clinic um, 2 days a month, and that's what I love doing. That's when I
Mm,
really feel like a lawyer. So I think it's important that, and Illinois and a number of states do this. You try to inspire people to do pro bono work. Illinois Supreme Court wants to know what type of pro bono work's being done. Are lawyers giving of themselves? Are they giving money? Are they giving time? It's probably the most positive thing that a lawyer can do at some point in their career and say, I want to represent this person or this cause.
I see. As we know from the 13 colonies until today, the legal profession did grow and transform itself. And right, right now, the legal profession have new members with different backgrounds and different races. What the legal profession is doing to welcome those minorities and allow them to um, evolve in the legal environment.
It's critical that the profession allow them to do what every other lawyer in that state does.
Mm,
The freedom to represent clients, um, to earn a living for the representation of the client, to have the same fairness extended to them by judges and
mm,
others within the system. It's critical. The biggest change in the profession has been in the last couple of decades is gender parity,
I see.
where you're seeing law schools now turning out more than 50% of their classes are women, and that's going to
Mm,
inevitably have a big impact. But it's so critical that we have lawyers that look like the world.
I see.
Um, I showed, I was talking to my students just my last class, about a case involving a lawyer that
Mm,
wasn't a bad lawyer, he just didn't like communicating with clients. And clients would always file complaints.
mm,
And eventually, that lawyer was disciplined because he didn't have a mechanism to be able to communicate with clients. And the court said this was horrible. And the opinion was drafted by the only woman on the Illinois Supreme Court at that time, Justice Marianne McMorrow.
okay.
And I showed a picture of the court when Justice McMorrow was a member. And now I showed a picture of the Illinois Supreme Court today.
Mm,
And it's obvious from looking at that picture today that the court is reflective of what the world looks like.
I see.
And as long as you have judges that look like the rest of the world
Mm,
and political officials that look
mm,
like the rest of the world,
mm.
that is good for the profession because it allows people the opportunity to represent clients to the best of their abilities.
I see. Um, Professor Grogan, again, uh, I will give you the last word, of course, but I just want to share my gratitude. You may not remember, but you were my first guest in this platform. So you gave me the courage to keep going, and you were part of giving birth to under the human rights tree, and I'm very grateful to that. But I just want to say thank you again for accepting my invitation, and I will give you the last word so you can close the conversation. Again, thank you.
Well, I'm very proud to know you. I'm very
Mm,
happy that you are doing what you are doing. And it's indicative, I think, of the best of law schools to turn
mm.
out people like you. So
Uh,
thank you.
thank you. And in the future, I will reach out again if I have any issue I would like to discuss to,
Always,
so you can share your knowledge. Again, thank
always.
you very much for sharing.
Thank you.
Bye. Mhm.
Bye.